And we are live.
Hi, everyone. So glad to be here today in the Purse Strings for Financially Fearless Women Facebook group. And we have Carissa Look here today. So really glad to be bringing you yet another expert, Purse Strings approved professional. And as many of you know, I'm Barb Provo, founder of Purse Strings, and my business partner here, Maggie.
Hello, I'm Maggie.
All things operational and everything else. We welcome you today. Thank you, California, for chiming in. Glad you're here. Chris is from California, so who knows? You may be neighbors. We at Purse Strings provide free online tools and resources so women have access to information, knowledge, and can enhance their skill, all things financial. So at our website, pursestrings.co, you'll see a plethora of resources there. You'll see some guides that you can download. You can see, let's see what else. Oh, Ask an Expert. There's a ton of blogs. Moreover, we have a whole list of Purse Strings approved professionals, all things financial, that at any point in time, if you need an attorney or like Carissa, or you need a realtor, a lender, any of these financial professionals, we vetted them and provided them training and resources to enhance their skill set in serving a female market. So I think the question is, where in California? Carissa, you said you were in Santa Barbara?
I'm in Solvang. Yeah, it's about 30 minutes from Santa Barbara.
Okay, cool. Sounds like a beautiful place, by the way. Every time I hear Santa Barbara, I think Hollywood for some reason. I don't know. It sounds like sounds like the lap of luxury, you know. Always beautiful weather. It's funny, like, do they have a weatherman there? Why would they? It's always beautiful. That's all they'd have to say, right?
Yeah, we've got Montecito where there's some celebrities living.
Yeah, and you're there, so there.
There's another celebrity.
Yeah, you're our celebrity, Carissa.
So yeah, we're excited to talk about, estates and trusts today. We jumped on the phone, Carissa and I, to talk about what we're going to talk about. And that was the first thing she said, she thinks is most important, which I won't take too much of that away because that's part of what we're talking about, of why that's so important. But I always love when we jump on and you guys know right away, like, what you want to talk about and what's most important from your profession to have the females to know. So that's always exciting. So we'll wait another couple minutes to make sure everyone's on before we get started.
Yeah, and we talk about, it's funny when we talk about estate plans and we talk about trusts, and even in our little ad blurb, people think estate plans are for people who have these palatial estates. And really, that's not necessarily true at all. So don't let the name fool you. And Carissa will explain why estate planning is so important, and then also explain trust. I mean, you hear the word trust, people kind of are like, I don't know, that sounds complicated. I don't think I need one of those, but you don't know, right? So Carissa is going to explain the estate planning and trust 101, so we can all step out on the right foot and learn from the beginning what we need, why we need, when we need. So that's great. Oh, we have Madison, Wisconsin joining us today. That's wonderful.
Great.
Hi, Madison. Yeah. Anybody else can jump in as well. We do stream here in our Facebook group, so people may be watching but not signing in. So welcome everyone out there.
Yeah, this should be fun. I think we should get started. So I'll give a little overview of Carissa, and then we can get rolling. So Carissa works as an attorney at a full service law firm. She provides counsel and representation to the clients in connection with transaction of their varied businesses, the resolution of their disputes, and execution of their estate plans and development, maintenance, protection, and their intellectual properties. So she's keeping everything secure and locked down, which is awesome. Let me pull up your slides here, and we'd love anyone to comment in the questions or participate at all during the presentation. So yeah. Let's remove you. We're gonna do a little bit of this. No, that's not what I wanted. Present. Oh, 1 second. Bum, bum, bum. Add to stream. This should, sorry, technology is messing with me. Sure. Alrighty. There we go. So Carissa, today we're talking about the 4 common myths about estate planning and why everyone needs them. So we'd love to have a little deeper introduction about you. Will you tell us a bit about yourself?
Yes. Hi, everybody. Good to have you here. As Maggie said, I'm an associate attorney practicing estate planning, and I do business law as well. I'm with Look and Locker. I've been with them since 2013. I got my degree at California Western School of Law in San Diego, and my firm has been practicing estate planning since 1987.
Wow, that's been a while now. So yeah, let's just dive into estate planning. We'll start there.
Okay. Well, I'd like to ask the question then, when you think about the word estate planning or about making a will or trust or planning to pass your assets on after your death, I wondered, how do people feel about that? Do you feel confident that you're going to get taken care of? Do you feel stressed about it, overwhelmed, confused? If anybody can just write maybe a few words about how they feel about estate planning in the chat, I'd like to know. Because I found with
some of these to come through.
What's that?
We'll give it a second for some of these to come through.
Oh, sure.
I can tell you I feel unprepared, if anyone was asking. You know, I've never thought about it too much and don't really prefer to think about my own death. But yeah, we got a couple people in here that just say, you know, fear and really just kind of confusion.
Okay. Yeah, I see someone says very important and comforting when it's done. Definitely agree with that. I've found a lot of our clients, as Maggie said, feel like they don't want to think about their death. Most of us don't. They want to, maybe they put it off. They think, I'll take care of that sometime, but they avoid it. Or, yeah, they might be stressed about the details of it. Is this going to be really complicated to get accomplished? How do I know what kind of documents I need? Well, I'm here to tell you that, first of all, it is very important to plan what happens to your assets after your death, as well as a few other issues I'll discuss that we plan for, no matter what you own. And that we can get it done for you without a lot of stress. And that's what we're here for, to lay it out simply and to let you know exactly what you need. And we can really help you eliminate that stress, or any attorney you work with, to get it taken care of. Someone else said, so important to plan and be prepared so your loved ones are protected. I definitely agree with that, yes. So a lot of you already have the right idea about what this is about and the importance of it. That's great. Okay, so I'm going to give you an overview about what I'm going to go over today, and what you'll have an understanding of at the end of this presentation. You will know what is meant by estate planning, 4 common myths about estate planning and why they are myths, what probate is, why you want to avoid it, and how creating a trust accomplishes that. And I'll go over the 4 main documents included in an estate plan. Okay. So we can move on to, oh yeah, perfect.
So yeah, let's dive into, you know, what really is estate planning and an estate.
Estate planning is planning for how your assets will pass and who they will pass to in the event of your death. Most people think of, who's going to get my assets after my death, but also important is how. And what I mean by that is, are you going to involve the probate court? Are you going to have a will, a trust? I'll answer all those questions today. But another big part of estate planning that a lot of people may not realize is we don't just plan for your death, but also possible incapacity, meaning someone's no longer able to care for their affairs. So we need to plan for who will make financial and medical decisions for you in that situation. And another part of it is if you have children, naming guardians for your minor children.
That's really important.
Yes. So now I want to talk about 4 common myths about estate planning.
So your first myth that you have here is I'm too young to start thinking about estate planning, which personally I feel like that's, would be my myth at the current moment.
Mm-hmm. Yeah, I can see why people might think this, but actually it is important to start thinking about it. Every adult can greatly benefit from having an estate plan no matter their age. Even a young person could pass away. We don't know when we might die. Maybe you're young, but you do own a home, or you do have more than, and the number is, I'll explain later, it's around $166,000 in assets. And then if you have either of those, you're going to need a trust, or your estate would have to be probated. And I'll talk more about what that means, but basically probate is much more costly and we like to avoid it always. Maybe you're young and you don't own a home or have much in your bank account. Well, in that case, you're not going to need a very complicated estate plan, but you still do want to think about other documents. As I mentioned, planning for incapacity. Say, forbid that you were in an accident, not able to care for yourself any longer. You would want to name somebody to take care of your finances and your medical decisions. And maybe you are young, but you have kids. You still want to name guardians for your minor children, so you'll need a will.
So it sounds like this one really covers, protecting anything you have over, it seemed like $166,000, which we'll talk about that magic number later. But if you have something that needs to be protected, bottom line.
Exactly. Yeah. No matter your age. And even if you don't, to think about planning for incapacity.
Definitely. So myth number 2 is estate planning is only for the wealthy, those who have that grand estate.
Yeah, so when we say estate planning, we don't mean an estate like, Oprah's estate over there near me in Montecito. It just means your assets, whatever that may be. And well, again, even if you don't own much at all, like I talked about, you're going to want that durable power of attorney, we call it an advanced healthcare directive, to plan for financial and healthcare decisions if you became incapacitated. Even if you're not extremely wealthy, but you do have over $166,000 amount or owned real estate, and if you didn't have a trust, your estate would have to be probated. And say even if you don't own much at all, well, you still might want to designate what you do have goes to. And if you don't name who you want it to go to, it may not go to who you want. So in that case, you still would want to create a will and those other documents I talked about.
So talking about a will, it leads us into myth number 3, that if you have a will, you don't need to worry about probate.
Well, again, it depends on how much you own in assets. It's that question of real estate or the over $166,000. If you have a will, say you own a piece of real estate, your estate's worth over $166,000, you think, oh, I create a will, so I specified who it's going to go to. Well, no, you're still going to, even with a will, the estate still will be going through the probate court. The only thing that's going to protect you from probate court is having the trust set up. Now, if your estate is worth less than the 166,000 and you don't own any real estate, then yes, you can just have a will and your estate would not need to be probated.
Interesting. And then last but not least, myth number 4 is that I can draft my own estate planning documents. I don't need an attorney.
Yes, and some people do this on their own, but I highly advise against trying to do that. We've had clients who've downloaded forms from the internet, they've used LegalZoom and done their own estate plans, and when it came time to administer them, meaning it passed away and it's time to distribute according to those documents say, their estate plans didn't accomplish what they had intended. They made some mistakes and the state ended up having to go through probate anyway. So those documents didn't protect them at all from, or didn't accomplish what they were trying to do. The problem is you probably won't even know what needs to be done. You might miss something. You could spend 6 hours searching on the internet and you'd get answers from people who might claim themselves to be experts but don't even understand it themselves, and or maybe you read some information but that applies to a different state and what they tell you is all wrong. And another problem, usually what ends up happening is people might create the trust, then the trust doesn't get funded, meaning assets don't get titled in the name of the trust. So it's like they have a trust but there's nothing in it, and it ends up not being useful at all anyway. So I really recommend this is something that you want a professional to do for you and get it done right. So then you feel secure in knowing where your assets are going to go. I see some questions in the chat. I don't know if I should address that now or at the end.
Yeah, the question was about the $166, but if you're going to get to that, we can wait until that portion.
I can just say real quick, yes, that is in California. It's actually 160 right now. It's 166,250. I just, for sake of not being wordy, I just said 166,000. And yes, that applies to California. So check your state for what their threshold is for probate. And like I know in Texas, states are really easy to be probated. So the law is quite different. And that number has changed. So right now, that's what it's at, 166,250 in California.
That's great. To go back to this myth, it's funny. I think there's a lot of things that we try to do ourselves. Even like I was like, oh, I could give myself my own haircut. And then I thought it through again, but there's a reason why someone's a professional in that area. If it was that easy, then we could all just be doing it, but it's not. And so there's definitely a reason why there's a professional there. And, quality, you get what you pay for and all those good things. So I think that's a great myth to bring up.
Right.
So
yeah,
from there, we keep hearing this word probate. What is probate? Am I frozen?
Oh. Okay, sorry about that.
No worries.
Well, probate could be defined as the legal process, which is done in the probate court for reviewing the assets of a deceased person, paying creditors, and determining inheritors. And the court supervises that process of distributions to who it's supposed to go to. The court is involved in every step of the process.
And so when would probate start after a person passes away? Do they go to court right away, or how long does this legal process take?
Yes, the executor in charge of the estate would contact the court right away. Yes.
Okay. So when does the estate have to be probated? Perfect timing.
Okay, so I want to compare here an estate would have to go through the probate court to be administered to heirs, and an estate that does not have to involve the probate court. Like I said earlier, so if you own real estate, and that's worth over $60,000 right now in California, or own over the 166,250 in assets, or both of those things. If you had that, then we are going to set up a trust for you to avoid probating estates, and as well as those other documents that go along in the package. If you don't have a trust, then the estate will have to be probated. And if you don't own any real estate, you own less than the 166,250, then in that case, you won't need a trust. We'll set up a will for you along with those other documents.
And how is this $166,000 number created, or what does it take it off of, based off of?
It's part of the probate code, and that number, it gets adjusted for inflation every year. So that's what they decided on in the legislation.
Interesting.
Yeah. Okay, so I want to do a little comparison here in a real life example. Well, not real people, but an example. And keep in mind that this is the cost that I'm going to talk about and the time involved. It's just an estimate, because until we know exactly what your assets are, maybe how complicated they might be, for example, a piece of real estate that has some encumbrances on it, different mortgages, that would be more complicated, so it might take longer. So this is just a general estimate. So we have Jim and Pam, and if there's any Office fans out there, the TV show The Office, that's one of my favorites, so that's why I use these names just for fun. They have an $800,000 estate, including their $400,000 home. Dwight and Angela have the same amount of assets, just to keep it simple here. Jim and Pam created with their attorney the Jim and Pam Family Trust and the full estate planning package. Dwight and Angela neglected to set up a trust for whatever reason. Maybe they were going to get around to it. They didn't even know they needed it. Jim and Pam's cost for their trust package with their attorney was about $2,000. Both spouses were deceased by 2021. So with Jim and Pam, their trustee, they may have named, their daughter or two of their kids. That person works with their attorney to accomplish the trust administration. And that took 9 months to complete. All the assets were distributed out to the beneficiaries, and that cost of the trust administration was $2,500. For Dwight and Angela, again, both of them were deceased by 2021, and their executor, now that probably would have been one of their children or both, or a few of them, works with the probate court to determine the validity of the will and distribute the assets. And they, had many court dates they had to meet, and that took 2 years, 7 months until everything was completed, the assets distributed out to the beneficiaries. Now the cost, this is the big deal here, was $40,000. So the cost of probate is generally around 5 to 6% of the gross value of your estate, which gross value of your estate is your total assets. We don't subtract debts that you owe or mortgages. So 5 to 6% of their total value, their $800,000 estate, is $40,000. So as you can see, Jim and Pam saved quite a bit of money, about 10 times less than Dwight and Angela's heirs ended up paying, that $40,000 that came out of their estate that could have gone to their children. So as you can see, if you're a person that needs a trust based on the value of your assets, it's really worth taking the time to set up that trust. You'd save time and a lot of money.
Sometimes it seems like a strange thing because you'll be dead, but it's really a gift that you give to your family. I mean, your family has that much more money. Your kids don't have to spend over 2 years going through all of this. I mean, it's just one of those things. I feel like, when someone passes away, you want to mourn and, do your grieving process and get on with life, not spend 2 years trying to get their assets and losing a bunch of money. So, it's a cost up front, of course, but, clearly we can tell that the return is really, really worth the investment.
Definitely. Yes, and that's why I really like to educate people about this, and I really want to see people save that money and time and the headache of it. I think it's a wonderful thing.
Wow. And so now we have this question come in that says, is it possible to do your own trust administration, especially if one of the spouses passes? Can't the other take care of it?
Well, there's two parts to that. So at the first death with a couple, we don't at that time do a lot of the administration. Usually all the assets would pass to that spouse that's still alive. There are a couple things we need to take care of, like filing an affidavit for a property to show that the other spouse can act as the trustee of that property. There are a few steps we take, but not nearly as much as at the second death. Mm-hmm. So, yes, if the spouse that's still surviving, they can take care of things. I would still recommend to work with an attorney to know what needs to be done, because they likely won't know. And then doing your own trust administration. I don't know if you also wondered about at the second death, if the trustee or the executor can do it at that time. Again, I wouldn't recommend they try to do it on their own, because there are quite a few steps that need to be taken, and I don't think most people would be aware of what needs to be done without working with an attorney to let them know, and really making it a lot simpler, so you don't wonder if you're doing the right thing or not. And so definitely better to work with an attorney.
Definitely. So what does an estate plan include?
A complete estate planning package. Now, if you're going to have a trust, will include your trust as the main instrument to name what you want done, who you want the assets passed on to. It will include a will, and I'll explain the difference between what a will looks like if you only have a will versus a trust. Why do you still need a will? Durable power of attorney is what we call the document that will name someone to take care of your finances if you were incapacitated. And then the advanced healthcare directive names someone to make healthcare decisions for you in that situation. Then there's some other ancillary documents that go along with the trust, mostly having to do with funding the trust. And then if you own property, we'll have a deed.
Wow, yeah, that's a whole bunch of paperwork that actually needs to be completed.
There's a lot to it, to the package. There are quite a few pieces of it. Yes. Mm-hmm. Okay, so the trust. What is a trust? It's a legal document holding the owner's assets. We might think of it like a box you put your assets in, not a literal box, but it helps to think of it that way. It holds the owner's assets during their lifetime, and it spells out how assets are distributed upon the owner's death. The owners are the trustees in charge of the assets, and then they name successor trustees to act when the owners have passed away, and that trustee will be the person working to distribute the assets to the beneficiaries. And by placing the assets in the trust, the probate process is completely avoided. You won't have to work with the court at all whatsoever. It's all done privately. You can also think of it like, you've got your assets here in your probate pocket on your left pocket, and the court wants to deal with those assets. You take the assets, take them out of your probate pocket, put them into your right pocket, your trust pocket, and it's like it's hidden from the court there in your trust pocket. The court doesn't see it for probate purposes. Okay, and then the will. Now, when people think about estate planning, they often will think of having a will. But as I explained, if you have a trust, the will won't be your main instrument. The trust will be, trust is the instrument that distributes assets to your beneficiaries. So why would you need a will if you have a trust? Well, when you have a trust, you each spouse, or if you're single, it's just yours, have what we call it a pour over will. And the purpose of the will then is to give instructions that any asset that was not titled in the name of the trust, when I die, pour it over into the trust. So the will acts as a safety net to make sure there's nothing left out of the trust that would end up having to be probated. So, for example, if you inherited a piece of property after you set up your trust, or you bought a vacation home after you set up your trust, now at that time you should execute a deed so that you have that property, that new vacation home, titled in the name of the trust, and then it becomes a part of the trust. But what if you forgot to do that and you pass away, you have this piece of property not covered by the trust? Well, the will instructs that that asset is poured over into the trust and considered being part of the trust asset, so that protects it from having to be probated. So it's nice to have that extra safety net. And of course, if we decide based on the value of your assets that you don't need a trust and you only need a will, then the will acts as the instrument to distribute the assets out to your beneficiaries, and it will name an executor instead of a trustee to handle your estate. Okay, then we have the durable power of attorney, that I kind of talked about already. That document will name an agent or agents to act for you regarding your financial affairs. They can sign contracts for you in the event of your incapacity, in the event you couldn't do that any longer on your own. If you're married, we'll name your spouse to do that for you first. If you're not, if you're unmarried, or they've already passed away, or the spouse isn't able to act, then we have an alternate agent. That person will act for you. Good to have a couple alternates for this one.
Mm-hmm, definitely.
And then the Advanced Healthcare Directive, the same idea, but naming a person to make healthcare decisions for you in the event you couldn't do that on your own. They were in the emergency room unconscious, they will contact that person you've named to know what your healthcare wishes are. Again, if you were married, first it would be your spouse, and then naming someone else or a few other people in line to do that.
And I do want to highlight while we're here, the Advanced Healthcare Directive, and I know the Durable Power of Attorney. These are things that are different. A different professional also recommended that, you need when you're 18, because if you're, sick at college, or, get in a car crash, you're 18 and your parents can't just come and talk to your doctor. You need these permissions. And so it's not just, some of these paperworks you need no matter what. And we recommend that you get at 18 because you are now a legal adult.
Yes, for sure. Every adult should have one. It's really good to have that in place. Advanced Healthcare Directive that you might have seen in your doctor's office, have you fill one out. You could do that, but the doctor's not going to help you fill it out or help you understand what it means. And our forms are quite a bit more detailed than one you would get from a doctor's office. So I would say at least have one of those filled out, but it's really great to do one with an attorney.
Mm-hmm. Definitely.
Okay, then with the trust are a few other ancillary documents. Remember, it's essential to fund the trust. That means, all your large assets, your pieces of property need to be titled in the name of the trust. We have documents that accomplish that. And, if you don't fund it, it's like you've got this shell of a trust with nothing in it. So that's a huge part of it. And there's a couple other documents that go along with the trust I won't get into now, but one of them is one of those to transfer larger bank accounts into the name of the trust. And then the deed, of course, will transfer your real estate into the name of the trust.
Awesome. And then we did have a question come through of, how does a doctor or a medical facility know who your healthcare power of attorney is?
Oh, that's a great question. So yeah, say you did the form with your attorney. They would contact probably your closest contact person. If you were in the hospital, whoever came to the hospital with you, they would ask them, and then that person would know, we have this document. They often ask for a copy of the document. So yeah, that will be taken care of.
So it's important for, your loved ones to know that you have this document, know where this document is, and, that it's there. And probably the person, who is the healthcare directive, should definitely know where these items are for their loved ones.
Yes, very well said. That's true.
And so, Carissa, how do we work with you and make our plan?
Yes. So, as I said, I'm Carissa Look at Look, Guthrie and Locker. I'm in California, so I'm only licensed in California, so I can work with people who are in California. If you're not, I hope that you gain something from this presentation and understand what estate planning is a little better. Some of it might apply to your state. Some of it might be quite different. So I would recommend contacting an attorney in your area to explain how it works in your state and work with them to create your estate plan. If you are in California, you can reach me. I have my office phone number listed here, my cell phone number, my email address. You can also message me on my Facebook page. I'm in the Purse Strings group. I think Maggie will share some more information about how to contact me.
She's a wonderful Purse Strings approved provider, so you can always check her on our site, pursestrings.co. But the last thing we wanted to finish up here today is if someone was going to work with you and make these documents, which you have shown us that, they are important and how much time and money they save, how much would this cost for them?
Well, here's my rates listed here for a trust package for a couple. Our standard rate is $24.95 for a single person, $19.95. A will package for a couple, which that would probably be pretty rare. We would need to do that, but we would charge $1,000. And for a single person, $750. I'd like to give anybody that wants to work with me from this group a discount. If you contact me before 4th of July, I would like to give the discounts I listed here for a couple, $19.95, single person, $14.95, for a will package for a couple, $850, and a will package for a single, $500.
That's a great offer, and we really appreciate you doing that for our community, because we have definitely shown today how important these documents really are.
Yes.
For sure. So we did have one more question come in, and that is asking if there's a checklist somewhere for the trust administration so we have an idea of what needs to be done in the event of a death. She also thinks it's important to list any valuables, who gets what, to avoid the conflict in the family. You don't want to leave, stirring the pot.
Yes, great questions. As for a checklist, I mean, we do have a general working checklist that we use for ourselves. It's not really an official document. You might be able to find online, someone that made a checklist like that too. I'm sure that that's listed somewhere, online. But again, I would recommend it. It's great to look at that, to have an idea of what needs to be done. Sure. And when we work with clients or at the time of administering the trust, we do send them documents that explain what needs to be done. But again, I wouldn't try to do all those things just on your own. I would work with an attorney to do them. And great question about the valuables. Along with the trust, we have what's called a trust schedule. And there we write, bank account numbers. We do have a section where we list valuables. We list personal property. It's not like we need to title each of those things in the name of the trust, but we list them on the trust schedule. And that shows that it's included as part of the trust. There you can specify to what valuables go to who in the family. So that's great to do to avoid conflict if that will be an issue.
Awesome.
Yeah.
This has been a wealth of knowledge for all our ladies out there. These are really important documents, as you discussed. Save a lot of time, a lot of money in the long run, and a lot of family conflict that might come up because you never know. You just never know.
Yeah, definitely.
Thank you, Carissa. I was most amazed at the kind of comparison to if you have these documents versus you don't, because some people just think, whatever. The time and the money involved is incredible. It's incredible.
Yeah, it really is.
Yeah, and I like that there's kind of that benchmark number of what you need when you need, that 166, 250, which I know is state specific now. And that I like the question about the checklist. I think that's something that maybe purse strings can pull together and run by you, Carissa, or other attorneys and say, is this something we can offer our community of women? We may have been through, I know I have, when my parents passed, people are just scurrying. Like, what do we do? How do we, you know what I mean? Who does what? And what needs to have happen? And if there is a dedicated checklist of, first, second, third, that would be a great guide to have. So something we'll look into. Yeah.
Yeah.
Awesome. Well, thank you again, Carissa, for coming on today and giving us all this great information, as well as a discount to all of our women out there. So you can always reach Carissa at Look at, I'm waiting for your screen to come by, Look at slgl-law.com. She's one of our Purse Strings approved professionals, so you can check her out on the Purse Strings page, pursestrings.co. And we'll pass out the handout tomorrow with all the overviews of the presentation, which will also have your contact information on there. So we appreciate everyone coming today, and we hope you feel financially fearless.
Thank you, Carissa.
Great. Thank you. Thanks, everybody.
Bye.
Bye.